All right, we've got this breaking news just coming into our newsroom right now. The Supreme Court has issued a ruling.
Now, this is the most significant Second Amendment ruling in more than a decade.
And the question is, what should be legally considered when deciding if an officer's use of force is justified?
There's a major development unfolding at the Supreme Court right now that every American should understand, regardless of where you stand on the political spectrum. A rare unanimous decision from just a few years ago that appeared to protect your home from warrantless police entry is now being weaponized in a brand new case that's heading for oral arguments this week. This ruling could completely reshape the circumstances under which law enforcement can enter your home without a warrant and seize your property. What makes this situation particularly urgent is that it involves the intersection of three things most people care deeply about: the sanctity of your home, your constitutional protections, and what happens when police respond to vague reports from people who claim to have a bad feeling about you. The case we're about to examine reveals exactly what can happen when constitutional protections get eroded through well-intentioned exceptions, and why the Trump administration's surprising position in this case has shocked Second Amendment advocates who expected very different support. The Supreme Court doesn't issue unanimous 9-0 decisions particularly often. Statistical analysis shows that only about 36% of cases result in all 9 justices agreeing on the outcome and reasoning. When you consider the deeply divided nature of the current court on many contentious issues, that number actually represents a relatively high degree of consensus compared to many other judicial bodies. But when all 9 justices, spanning the entire ideological spectrum from the most conservative to the most progressive, unanimously agree on something that involves both gun rights and Fourth Amendment protections against unreasonable searches, that's a signal that something fundamental about constitutional law was at stake. The landmark case that established this rare unanimity was Caniglia versus Strom, decided in 2021, and it struck down what law enforcement agencies across the country had been using for decades as legal justification for entering homes without warrants. This doctrine was called community caretaking, and understanding where it came from explains how it got so badly misused. The community caretaking doctrine originally emerged from a 1973 Supreme Court case that dealt specifically with searching vehicles, not homes. The reasoning made sense in that limited context. When police encounter an abandoned car on the side of a highway, they might need to check if someone inside needs medical help, or if the vehicle poses a hazard to other drivers, or if it's been used in a crime. These are legitimate public safety functions that don't necessarily involve criminal investigation. But here's what happened over the subsequent decades. Police departments across the country gradually stretched this vehicle-specific doctrine to justify entering homes without warrants whenever they claimed to be performing some community caretaking function. The expansion was gradual enough that it didn't trigger immediate constitutional challenges, but broad enough that it effectively created a massive exception to the Fourth Amendment's warrant requirement. The case that finally brought this issue before the Supreme Court involved a domestic dispute that escalated in ways that reveal exactly how these doctrines get abused in practice. A husband and wife got into a heated argument at their home. During that argument, the husband grabbed his handgun, placed it on the table in front of them, and said something that sounded alarming. "Why don't you just take it and put me out of my misery?" Those words, spoken in anger or frustration, prompted his wife to call the police. When officers arrived and accompanied her to the home, they found Mr. Caniglia sitting calmly on his front porch. There was no emergency in progress, no one was injured, no crime was actively occurring. He was simply sitting outside, having apparently calmed down from whatever emotional state had prompted his earlier statement. But here's where the situation went from concerning to constitutionally outrageous. The officers convinced Mr. Caniglia to go to the hospital for a psychiatric evaluation, something he apparently agreed to do, possibly to avoid further conflict. After he left with paramedics, those same officers went to his wife with a request to search the home for firearms. When she hesitated, they told her an outright lie. They claimed her husband had already consented to them taking the guns. Based on that false representation, she allowed them to enter the home and seize the firearms. When this case finally reached the Supreme Court after years of litigation, all 9 justices agreed this was a clear constitutional violation. Justice Clarence Thomas wrote the opinion, joined by every other member of the court, declaring that the community caretaking exception applies to vehicles but does not create a standalone doctrine that justifies warrantless entries into homes. That should have been the end of the story, a strong, unanimous reaffirmation that your home receives the highest level of Fourth Amendment protection. But what most people don't realize is that the Caniglia decision left a significant loophole open, and that gap is now being exploited in ways the justices might not have fully anticipated. While the Supreme Court definitively shut down the community caretaking doctrine for residential entries, they left completely intact something called the emergency aid exception. And this is where things become genuinely dangerous for anyone who values privacy and constitutional protections. The emergency aid exception allows police to enter homes without warrants when they have what's called probable cause to believe someone inside needs immediate assistance. The classic examples make intuitive sense. Someone having a heart attack visible through a window, smoke or flames indicating a fire, screams suggesting an active violent crime in progress. These are genuine emergencies where requiring officers to obtain a warrant before rendering aid could result in death or serious harm. Nobody seriously argues that police should stand outside listening to someone die while they wait for a judge to sign paperwork. But here's the problem that's emerged. The definition of emergency has become remarkably elastic in how lower courts interpret and apply it. Recent legal analysis examining warrantless home entry cases from 2023 reveals that emergency aid exceptions are now being invoked in over 40% of all cases where police enter homes without warrants. Even more concerning, the success rate for law enforcement defending these entries in court is approximately 73%, meaning courts are upholding these warrantless entries in nearly 3 out of 4 cases where the issue is litigated. Montana and several other states have been pushing to lower the standard even further, and this is where the constitutional danger becomes acute. Instead of requiring probable cause that an emergency actually exists, they want courts to apply a much more subjective standard based simply on reasonableness. The difference between these two legal standards might sound like semantic hair splitting, but it could mean the difference between your home being a constitutionally protected sanctuary and just another location police can enter based on instinct or suspicion. Probable cause means police need concrete facts and circumstances that would lead a reasonable person to believe an emergency is actually happening right now. It requires articulable, objective evidence, not hunches, not possibilities, not vague concerns. The reasonableness standard Montana is advocating for is dramatically lower. It essentially asks, would a reasonable officer think entering might be a good idea under these circumstances? That's a far more subjective test that gives enormous deference to police decision-making in the moment. And there's a specific case working its way through the courts right now that demonstrates exactly how catastrophically wrong things can go when we adopt this lower standard. Trevor Casias' situation is the nightmare scenario that reveals what happens when constitutional protections get watered down through well-intentioned exceptions. His ex-girlfriend called police to report that she'd had a phone conversation with Trevor that gave her a bad feeling. When officers arrived and questioned her further, she admitted she couldn't actually remember the specific content of what Trevor had said during their call. She just had a feeling something was wrong and speculated that maybe he might have a confrontation with police. Think carefully about what's being used as justification here. No specific threat was articulated, no clear statement of intent to harm himself or others, no weapon was observed, no crime was reported. Just a feeling from an ex-girlfriend who couldn't even recall the details of their conversation. Police went to Trevor's home and knocked. He didn't answer. According to legal filings and expert analysis commissioned by Trevor's family, what happened next occurred with shocking speed. Officers entered the home without a warrant, encountered Trevor in his bedroom, and one officer fired his weapon in approximately 0.4 of a second, less than half a second from seeing movement to pulling the trigger. Trevor was shot in his own home, having committed no crime, during a warrantless entry justified solely by his ex-girlfriend's vague bad feeling and his failure to answer his door. The Montana Supreme Court, in a narrow 4-3 decision that revealed how divided even state high courts are on these issues, ruled that the warrantless entry was justified under the emergency aid exception using the reasonableness standard. Think about the precedent this establishes. An ex-partner makes a vague report based on a feeling they can't even clearly articulate. Police arrive at your home. You don't answer your door. Maybe because you're not home, maybe because you're asleep, maybe because you're exercising your right not to speak with police without an attorney present. Under the reasonableness standard, your failure to answer can itself be interpreted as evidence that something is wrong, making entry reasonable. You end up shot in your own bedroom, having broken no law. What makes this case even more significant is what happened when it reached the Supreme Court and various parties filed briefs stating their positions. The Trump administration weighed in through the Department of Justice, and their position shocked many Second Amendment advocates who had expected them to argue forcefully for stronger Fourth Amendment protections. Instead, The administration sided with the state of Montana and explicitly argued for the lower reasonableness standard rather than requiring probable cause. Their legal reasoning was that probable cause only applies to the issuance of warrants themselves, not to every type of search or seizure that might occur. The administration was then granted something relatively rare in Supreme Court practice: permission to participate directly in oral arguments, which are scheduled for this week. The implications extend far beyond just Trevor Casias' tragic situation. If the Supreme Court adopts the reasonableness standard that Montana and the Trump administration are advocating, it would apply to every emergency aid exception case nationwide. Given that these exceptions are invoked in roughly 40% of all warrantless home entries based on current data, we're talking about a massive category of police-citizen interactions where the constitutional standard would be fundamentally lowered. Trevor's attorneys have fired back with what many constitutional scholars consider a devastating argument. Even the Trump administration and Montana can't agree among themselves on how to actually apply this reasonableness test in practice. If the lawyers who are proposing this standard can't agree on how it works, how is a police officer supposed to correctly apply it in a high-stress situation at 2 in the morning when seconds matter? But there's an even deeper concern here that most legal coverage is overlooking. The real danger of the reasonableness standard isn't just that it's vague or subjective, it's that it creates a perfect storm when combined with other legal tools that have proliferated in recent years, specifically red flag laws and so-called wellness checks. Here's the nightmare scenario that keeps constitutional attorneys awake at night. Someone reports that you seem off or makes a vague statement expressing concern about you. Police arrive to conduct a wellness check. You don't answer the door because you're not home, you're asleep, you don't feel well, or you simply don't want to talk to police without legal counsel present, which is your absolute constitutional right. Under the reasonableness standard, your failure to answer could itself be considered evidence that something is wrong, making warrantless entry reasonable in the officer's judgment. Statistical data from Rand Corporation research shows that approximately 19,000 extreme risk protection orders, commonly called red flag orders, were issued in 2021 alone across states that have enacted such laws. The Casease versus Montana decision could effectively create a warrant-free pathway to temporary firearm confiscation that bypasses even the minimal due process protections that red flag laws provide. Instead of requiring any judicial process whatsoever, police could enter based solely on reasonableness, seize firearms as part of the emergency, and leave the burden on you to prove after the fact that the entry wasn't justified. What makes this moment especially critical is that the Supreme Court's decision could either strengthen or severely undermine that rare unanimous Caniglia ruling from 2021. Trevor Casias' legal team argues that police officers, firefighters, paramedics, and social workers who respond to genuine emergencies need clear, objective standards, what lawyers call bright-line rules, not subjective standards that vary based on individual interpretation and the particular circumstances of each situation. The question before the court is fundamental. Does your home remain your constitutional castle with strong protections requiring objective evidence before police can enter without a warrant? Or does it become accessible to law enforcement based on subjective assessments of reasonableness and reports of bad feelings from people who may have conflicts with you? Oral arguments in Casease versus Montana are happening this week, and the questions the justices ask during those arguments will reveal everything about how they're leaning on this critical Fourth Amendment issue. The outcome will determine not just Trevor Casias' case, but the constitutional standard that will govern potentially hundreds of thousands of police-citizen interactions every year across the country. This is about far more than gun rights. It's about whether your home remains a sanctuary protected by the Constitution's strongest language, or whether that protection gets watered down to the point of meaninglessness by exceptions that swallow the rule.